This is Lori Chaitin. I'm the director of the Reproductive Rights Project for the ACLU of Illinois, and I'm here with my colleague Amy Meek, and we've spent a lot of time working on issues relating to pregnancy accommodations in the workplace, as well, including pumping accommodations over the last number of years in a lot of different contexts, and we're really honored actually to be here today with you and happy to share some knowledge and some resources so that we can continue to try to make all of the workplaces in Illinois friendly to moms who are lactating and need to pump. So here, thanks. I'm going to just tell you a little bit about the ACLU's Reproductive Rights Project. So our mission is to make certain that all in our society have access to safe and effective contraception, sexuality education and information, reproductive technologies, prenatal care, childbearing assistance, and safe, legal, and accessible abortion. Our goal is to guarantee that all people have access to the information and resources necessary to make fully informed and independent choices about their reproductive lives and, frankly, about their medical circumstances generally, and to assure that women can participate fully in the professional, academic, and social spheres of our society. So we do this through, we have like a three-pronged approach: litigation, legislative and regulatory advocacy, and public education. We have a long history of filing lawsuits to challenge laws that restrict access to reproductive health care, including abortion, contraception, prenatal care, believe it or not, laws that restrict access to prenatal testing. We've had to go to court to challenge those. We do our legislative and regulatory advocacy. We work to defeat bills that are introduced that would impede access to reproductive health care or would remove the ability of patients to make informed, private, autonomous decisions about their health care. We also work to advance affirmative legislative initiatives to broaden access to reproductive health care and to support the ability of women to participate equally in the workplace, academia, and society in general. And then finally, our public education prong, we work to raise public awareness about these issues through press and public speaking and trainings and webinars and things like what we are doing today. So I want to tell you just a little bit about the kind of work we've been doing in this area, give you a quick overview, and then turn it over to Amy to get into the specifics. So a few years ago, the ACLU's Reproductive Rights Project drafted and then led a coalition effort to pass Illinois' new pregnancy accommodations law. And we were really excited. It passed in 1 year, and it went into effect on January 1st, 2015. And it requires all employers in Illinois to make reasonable accommodations for women who are pregnant and women who have delivered children and have pregnancy-related issues, including lactation. We represented actually a UPS worker who had been forced onto unpaid leave because of her pregnancy, and we got her back to work as soon as the new law went into effect. So we were very excited about that. We have successfully advocated with the Illinois bar examiners to implement policies that allow women who are pumping to have appropriate breaks during the bar exam in order to do the things that they need to do in order to continue to pump breast milk. And we are currently representing a Chicago Fire Department paramedic relating to her efforts to try to obtain reasonable accommodations to pump in the workplace. And so we're looking at this from a number of different perspectives. We're delighted to hear from you if you are having issues, but we're hoping that this sort of Know Your Rights webinar will give you the materials that you need and the knowledge and support that you need so that you can address these issues with your employers. So now I'm going to hand it over to my colleague, Amy Meek, who will get into the details.
Hi, I'm Amy Meek. As Lori and Katrina mentioned, I'm an attorney with the ACLU, and just personally, I wanted to mention that I have 2-year-old twins, and so my pumping days are not that long ago. I pumped for over a year at 2 different jobs, so I have been fortunate to have really accommodating employers, but I have a little bit of personal experience with some of the challenges. And I also just before I get into the details, I wanted to mention that we will be making this presentation available to you after this webinar. And so in terms of being able to access those the links and not having to write down every single detail that appears, because in some cases these slides have a lot of detail that I may kind of skim over. So just to give you kind of an overview of where I'm going with this, I'm going to give a brief summary of your rights in Illinois, talk mostly about the protections under the Illinois Human Rights Act, which is a relatively new law because those apply to pretty much everyone and have really the broadest protections. I'm going to then talk about how that law sort of applies to how you might think about approaching your own personal employer to talk about accommodations for breastfeeding. And then I'll just kind of more briefly touch on some of the other laws that do provide protections in Illinois, and then just give some more links to resources and tips. So just to give an overview for how these laws protect you in Illinois, there are about 5 different laws that apply in Illinois to women who breastfeed, and the upshot is that employers must make reasonable efforts to accommodate breastfeeding employees, and specifically they need to provide reasonable breaks for you to pump and a private area, not a bathroom or a toilet stall to pump in. Also that an employer cannot fire, refuse to hire, or retaliate, meaning they take a negative action against you because you're breastfeeding or because you've asked for accommodations to express breast milk. And so even though there are several different laws that may apply, that's sort of the upshot of them all. Those are your rights. Moving to the Illinois Human Rights Act, as Lori mentioned, the ACLU helped to draft and pass this law. It went into effect just over a year ago on January 1st of 2015, and it prohibits all employers from discriminating based on childbirth, pregnancy, conditions relating to childbirth and pregnancy, and this includes lactation. That's explicit in the law. And discrimination means, again, refusing to hire, firing, discipline, really any kind of negative action in employment against you based on those conditions. And just as a note, obviously this presentation focuses on accommodations for pumping, expressing breast milk, but this process that we're going to talk about applies to also if you're pregnant and you need accommodations for your pregnancy or for conditions relating to pregnancy or to childbirth. And just another note, I'm going to try and talk about some hypothetical situations, but because this law is pretty new, there's not really case law. We don't really know how courts are going to interpret some of these things. We're not necessarily going to be able to answer questions about specifically how a court would rule on a specific situation. So again, the Illinois Human Rights Act is very, very broad. It includes all employers, no matter how many employees, and that includes government agencies, private employers, employment agencies, labor unions, apprenticeship committees, and it also covers all employees. So whether you're part-time, whether you're full-time, if you're on probationary status, whether you're salaried or hourly, it applies to all employees. It also applies to job applicants, so somebody who's applying for a job and isn't hired yet, and apprentices. There are a couple of extremely minor exceptions that I'm not going to get into, but suffice it to say, if you think that you are an employee or you might be an employee, it's going to cover you. So in terms of what the law requires that an employer make reasonable accommodations for which are reasonable temporary changes that let somebody do the job's essential functions while they're pregnant, or more to the point here, while they're lactating. And in terms of what is a reasonable accommodation, it's a reasonable accommodation if it doesn't pose an undue hardship to the employer, which means that it's prohibitively, that it's too expensive or it's too disruptive. And this is really going to depend very much on what your job is, what your workplace is like, and what your employer is. So how expensive is this request for accommodation, you know, and how big an employer you have, what kind of resources they have. And it's on the employer. If they say that it's an undue hardship, the burden is on them to show why. And also, if your employer gives similar accommodations to others, then that suggests that there's no undue hardship. So in the pumping context, if they give breaks to other people to accommodate their needs, then that suggests that they can give you a break to express breast milk. So what happens under the law when somebody asks for accommodation? When you go to your employer and you say, I'm planning on breastfeeding and I will need some accommodations for pumping at work. So under the Illinois law, when someone asks for accommodation, the employer has to have a timely, good faith, and meaningful conversation with them about reasonable accommodations. So you don't have to guess what is reasonable or not reasonable. Your employer has to talk to you about it and have a conversation where the idea is that you're both going to work together to figure out what is reasonable based on your job, on your workplace, on your employer's needs and resources. As part of this conversation, the employer can suggest alternatives to whatever it is that you're requesting, but the employer cannot retaliate against you just for asking. So your employer can't punish you just for asking for accommodations to pump at work. And the Illinois law also gives some pretty specific examples of reasonable accommodations for pregnancy, childbirth, and related conditions that include lactation. And, again, this doesn't mean that these specific accommodations will be reasonable in every circumstance, but it gives you an idea of what the law, thinks is probably reasonable for most employers. And that includes private non-bathroom space for pumping, includes break time, it could include changes to your work schedule, it could include seating, and it could possibly include temporary reassignments. And the law also says some things about what is not a reasonable accommodation. So in the regulations, they say that your employer is not required to provide you with a breast pump or other what they call personal accommodations of a personal nature. The law also says that your employer isn't required to create additional employment. They're not required to fire anybody, transfer somebody who has more seniority than you, or promote somebody who's unqualified, which I think seem pretty self-evident as examples of things that are not reasonable to expect your employer to do. It does say, though, that if the employer has a policy of doing that to accommodate other employees who need it, then it actually might be a reasonable accommodation. So getting a little bit more into this process and this conversation that you have with the employer under the law, again, your employer, if you go to your employer and say, I need accommodations for pumping at work, and you have some suggestions or some ideas about what types of accommodations you think are reasonable, your employer can come back and suggest some alternatives. And if they suggest those alternatives, you have to consider them in good faith. So both you and the employer need to be operating, in good faith and really trying to work together to find a reasonable accommodation. And in considering that, the question is that alternative going to accommodate the need without additional cost or disruption? So, an example might be, maybe where you work in a cubicle that doesn't have a door, so it's not going to be a private space for pumping. Suppose you go to your employer and you say, there's an empty office down the hall that has a door. I'd like to move all my things into that office and use that during the time that I'm pumping. That's I think a reasonable request. Your employer might come back to you and say, you know what, we don't want you to move your workspace. We think that will be disruptive, but there is an empty conference room, and, we're proposing that every time you need to take a break,